A very good evening to all the members present here for this excellent meeting. May I now request our Vice President CA Vinod Kothari ji to kindly give his welcome address.
Good evening, all the members. Pleasant, warm welcome to all. Special welcome to our speaker of the day, Mr. Vardhan, who is going to enlighten us on decoding the new labor codes. Today, we have seen that compliance has become a big challenge. Total compliance has become technology driven. Lot of changes is happening on side of the government to implement new methodologies for the purpose of compliance. One big change which we saw was the region of indirect taxes, where earlier VAT, excise was there, and now it is changed to GST. One gray area where very few members practice is the labor law. This area, very few members practice, and so it has been the ACA's knowledge sharing session to ensure that whenever a new act or new knowledge sharing has come, we always try to deliver it to our members. So today we have our respected speaker, Mr. Vardhan, who will enlighten us on the decoding the new labor codes so that we can use it for our professional benefit. Thank you.
Thank you, Vice President, sir. May I now request our member Jayalakshmi Madam to kindly introduce the speaker.
Good evening and a very warm welcome to everyone once again. A very special welcome and special thanks to our guest, Mr. K. Varadhan, for joining us today. It is my privilege to introduce our guest speaker who will be addressing us on the topic Decoding the New Labor Codes. Mr. Varadhan is an eminent speaker, trainer, and an expert having over 30 years of experience in HR and labor compliances. As a graduate in mathematics and law, along with a PG degree in personal management and counseling, Mr. Varadhan began his career with TVS & Sons Limited in 1988 as personal manager. During his tenure, he played an active role in business expansion and right-sizing of workforce. In 2005, he became part of the leadership team of Aparajita and played a key role in stabilizing the flagship activity of compliance management services. Presently, he is the Chief Consultation Officer of Aparajita. He is also associated with employer bodies such as CII, EFSI, and NIPM. He has organized National Conclave on Industrial Relations multiple times and facilitated several training programs and workshops. He has also been a visiting faculty for premier management institutes, including Symbiosis Center for Management and HRD, Pune. Needless to say, his training sessions are not just informative, but also very engaging. Without further ado, I invite Mr. Varadhan to start the discussion. Over to you, sir.
Thank you, Jayalakshmi ma'am. Speaker, sir, the floor is yours.
Yeah. Yeah, thank you so much for that introduction, and thanks to the Association of Chartered Accountants, Chennai, for the opportunity given. Maybe I think there are 4 labor codes. I don't think we would be able to discuss all the provisions of these codes, but let me try to highlight the changes which are significant from what is existing today and how it is getting changed. So more the ideas I'll be throwing. That is what I'm planning. I'll maybe, without wasting further time, I'll just move on to my presentation part, and this is going to be my flow, right? So a kind of background, the context, and I may take some time to discuss on specifically the definition for the term wages. In fact, I think it is getting changed now, and one interesting thing is the definition is going to be uniform for across all the legislations in the labor domain, and this is expected to have a significant impact maybe on payoff or on ESI or gratuity or bonus, whatever it is. So I just thought I could spend some time on that. Then I'll get into the highlights of the other changes, maybe code-wise. That is what I've planned. With this, maybe I'll move on. So you must be aware the subject labor as well as social security. I think both are very important for the domain called labor domain. So both labor and the social security are in the concurrent list of the Indian Constitution. So both the central government as well as the various state governments will have powers to enact laws on these both these subjects. And whatever change we are talking about, it is happening only in the central sphere, right? Take for example, yes, we have a legislation called Tamil Nadu Shops and Establishments Act. It is a state-specific legislation. Absolutely no change in that. We have Tamil Nadu Labour Welfare Fund Act. We have Tamil Nadu Industrial Establishment National Festival Holidays Act, right? So all these legislations are not getting impacted. These are all state-specific legislation. You must be aware, I think people are estimating that there are nearly 44 central labor laws and umpteen number of state laws. On an average, each state will have 5 laws at least. So overall, 36 or 37 states, including the union territories we have. So 37 multiplied by 5, I think that should come to 185, right? So 185 plus 44 central legislations. So the number will go, it will come around 230, and that will not just stop with that. Each legislation will have set of rules framed. Particularly when it happens to be a central legislation, then that will have central rules as well as 35 sets of state rules. Right, so that is how it is going. So I think total put together, the number of legislations, the number of rules for compliance purpose, if you look at across the country in the labor domain itself, I think that will touch 700 at least. So that is the volume now. But whatever change we are talking about now, the 4 labor codes, it is pertaining only to the central legislation, central labor laws. It is not touching upon the state laws. And of course, the central government as well as the various state governments are in the process of framing the rules, right? I think ambitiously the government was planning to complete it before December this year, but I think that is not at all possible. And of course, they are taking steps, and states are also working on it. And it is likely that these labor codes can come into force from April 2021. Maybe at the earliest, if we can say, it could be from April 2021. So what is the rationale behind these labor codes? I think it all started with the economic reforms which happened sometime in 1991. Under I think when Mr. I think the liberalization, privatization, globalization happened at that time. Since that time onwards, in fact, the industries have been asking for corresponding labor reforms, right? But I think no much efforts were put on at that time. But maybe sometime during 99 and 2004, when Mr. Vajpayee was there, he constituted the second National Commission on Labor, right? I think they did some survey, and they made a recommendation sometime in 2002, and they said, in fact, the existing set of legislation, central legislations, central labor laws particularly, that could be maybe consolidated into just 5 laws. That is, one is on industrial relations, second one is on wages, third one is on social security, fourth one is on safety, and the fifth one is on welfare and working conditions. So that was the recommendation given by the second National Commission on Labor as early in 2002. Unfortunately, before further proceeding on that, in fact, in 2004, again, the political scenario changed. And for the next 10 years, I think absolutely there was no movement on this score. Then again, from 2014 onwards, again, the present central government, I think they are taking some steps to bring in some reforms under in the labor domain. And of course, the idea is, again, is to amalgamate, simplify, and rationalize the existing set of labor laws, particularly which are there in the central sphere, central labor laws. And of course, that should also make the implementation easy for the industries. And you may be again aware there are multiplicity of definitions. I think even if we take, for example, the definition of the term salary or wage, I think the same term is defined in every legislation, and the definition will also vary from one legislation to another legislation and one state to another state. That is a possibility currently, right? So somehow the idea is to maybe reduce the multiplicity of definitions as well as the multiplicity of the authorities. We have multiple authorities exercising, maybe enforcing these laws. Currently, I don't think any specific reduction in the number of authorities who are enforcing it. It is not taken up, but it can happen, or maybe because of usage of technology, it could automatically come down. That is the idea. And the proposed codes would bring the use of technology, as I said. The idea is again transparency. It should bring transparency. It should bring accountability. It should bring consistency. It should bring uniformity. That is the idea again. And I think, yes, we know that some of the stakeholders are leveraging these existing set of laws for their personal gains. I think that could also be avoided once technology is in place. And another point is to bring in flexibility in the dynamic factors. Say, for example, when I say the working hours, say in a factory, right? So currently, Factories Act is a central legislation, and whatever working hours prescribed, it is applicable across India for all the factories, right? But now I think the government is they have proposed to give parts to the appropriate governments. So maybe based on based on the situation in their geography, the appropriate governments can fix the working hours. So it is a dynamic factor. So the powers are given to the respective governments, the appropriate governments, to fix whatever the dynamic factor they want to fix, they can do that. That is the idea. Then ultimately, yes, this should help in setting up of more enterprises, which means increase in the number of businesses. Again, that should automatically lead to the number of employment opportunities. That is the ultimate idea. So it is more for business, increasing the business and to increase the employment opportunities. And of course, with respect to the penalty, it is going multifold now, right? The quantum of punishment. And of course, at the same time, the compounding of offense is also introduced. Almost under all the 4 codes, it is done. So this is the rationale with which the government is coming up with the set of labor codes. And I think in our screens, you are looking at a huge list of legislations. I think it is numbering 47 in total. And from 37 serial number onwards, you can see it. It is in red font. I think those 11 legislations, they are already repealed. So currently there are only 36 legislations, right? So I think you must be hearing that people saying the 44 legislations, central legislations are getting now subsumed into just 4 codes. It is not exactly 44. When I did some research, I think the total number comes to 47. But out of the 47, 11 legislations have been already repealed. So only 36 are remaining. Again, it is not the entire 36 set of legislations getting subsumed into 4 codes. It is only 29. So maybe for your information, these are all the list, right? So starting from Employees State Insurance Act, PF, Dock Workers, Mines Act, I think up to Employment Exchange Act. These are all the 29 legislations. So if you take code on wages, there are 4 legislations. If you go for occupational safety, there are 13 legislations. So 4 plus 13, 17. And if you go to social security, there are 9. So 17 plus 9, it is 26. If we go to industrial relations code, then I think existing 3 legislations are getting subsumed there. So 26 plus 3, 29. So these are all the complete list of 29 legislations, which are now getting subsumed into 4 codes. And it is not exactly the 44 as it is maybe quoted in the public. So what is the status? Again, we all know the code on wages, it was passed in the parliament last year itself, August 2019. With respect to the other 3 codes, occupational safety, health and working conditions code, the Industrial Relations Code, and the Code on Social Security. All the three codes, I think these codes were passed sometime in September 2020, right? I think one day after that, the industry suddenly became very active, and I myself am handling a lot of sessions on this. Since I think people have come to know of it, and they are also expecting that this could be implemented at any time. I think they have that interest. That is quite natural. And specific to Code on Wages, so these are all the 4 legislations which are getting subsumed into Code on Wages 2019. So the Minimum Wages Act 1948, the Payment of Wages Act 1936, the Payment of Bonus Act 1965, and the Equal Remuneration Act 1976. And Occupational Safety, Health and Working Conditions Code, it contains the list of 13 legislation starting from the Factories Act. So Factories Act, Mines Act, Contract Labor Act, Interstate Migrant Workmen Act, Plantation Labor, and up to Cine Workers and Cinema Theatre Workers Act. You can just go through the list. And Code on Social Security, again, starts from Employees Compensation Act, the erstwhile Workmen's Compensation Act, one of the earliest legislations. It was enacted in 1923. I think 1926 it was Trade Unions Act, and 1929 it was the Trade Disputes Act. Subsequently, that act got repealed as Industrial Dispute Act in 1947, and I think Industrial Dispute Act remains as the backbone of the entire set of labor legislations. And of course, employees' compensation, ESI, PF, employment exchanges, maternity benefit, payment of gratuity, then Cine Workers Welfare Fund, BOCW, where Workers Cess Act, then Unorganized Workers Social Security. These are all the 9 legislations now getting subsumed into one code called Code on Social Security. And finally, the 4th code, Industrial Relations Code, it has 3 legislations: the Trade Unions Act, then Standing Orders Act, and the Industrial Disputes Act 1947. So this is how it is now, and I think we will wait for the rules. So once it is ready, I think these codes will come for implementation. And again, this is more for statistics. Maybe I would like to draw your attention to Code on Wages. So number of sections currently it is 115. All the 4 legislations put together: minimum wages, payment of bonus, and the equal remuneration. All the 4 legislations put together, the number of sections is 115. But all these 4 now getting into one code, Code on Wages. But in the Code on Wages, the number of sections is only 69, right? And of course, rules, it is coming down from 67 to 58. Of course, it is only draft rules. It is yet to be passed, but still I am saying. And the number of terminologies, terms defined, it is 46. All the 4 existing legislations put together. That is now coming down to 26 under the code, right? So then comes the transactional activities, compliance activities, the number of returns to be filed. So from 3 to 1. The number of statutory registers to be maintained from 14 to 3. The number of abstracts to be displayed, it is coming down from 2 to 1. Similarly, the number of statutory notices to be displayed, it is coming down from 2 to 1. So it is very clear, everything is, the volume is coming down, right? So it is not just only for Code on Wages. You can just have a glance on the other codes also, except IR code. I think where I have encircled it in red font, I think the number of sections is going up because of some new provisions introduced. I think it is going up from 88 to 104. Apart from that, rest items, I think the volume is very clearly coming down, whether it is number of legislations or number of sections or number of rules or number of registers to be maintained or number of returns to be submitted, everything. So the volume is very clearly coming down. Okay, so now we are moving on to the second part. So this is the definition for the term wages. Interestingly, this definition has all the 5 parts: the substantive part, the inclusion part, the exclusion part, the proviso part, and the explanation also it has. And yes, it says that all remuneration by way of salaries, allowances, or otherwise. So whatever is paid as per the terms of employment, that is a contract of employment. We call it as appointment order. So if it can be expressed in terms of money or capable of being so expressed, that would be considered as wage. That is very clear. And it specifically includes basic, day earners allowance, and retaining allowance. Retaining allowance may not be applicable to all the industries, because when we say retaining allowance, it is more, it pertains to the seasonal industries, right? So where the employer in a seasonal industry would like to retain the services of the persons even during the non-season period. So during that time, I think he will continue to pay some amount, right, so that these people can be retained and so that they will come for work for the next season. So that is the idea. So that payment is actually called retaining allowance, because there is some misconception about this component, but still that is the reason I'm explaining. It may not be applicable in its strict sense to other perennial industries. It may not be applicable. Otherwise, when you look at the exclusion part, I think it starts from class A, from bonus, and it goes up to retrenchment compensation, class K, right? So nearly 11 components which are very specifically excluded. Interestingly, maybe whatever I have mentioned in red font, class D, class F, G, and H, I think conveyance allowance, that is getting excluded, right? Very specifically. Then HRA, it is excluded. Remuneration payable under any award or settlement, again, that is excluded. Any overtime allowance, that is excluded again. So when we say the definition for the term wages and these components are excluded, so these will be excluded for the purposes of minimum wages, payment of wages, bonus, and equal remuneration, right? But very clearly it says instead of all the four, because all the four are now getting subsumed into code on wages, but instead of the four, these are all considered as excluded wages only for the purposes of minimum wages and bonus. I repeat, these four components: conveyance, HRA, remuneration payable under any award or settlement, overtime allowance. These four components are considered as excluded part, excluded wages only for the purpose of minimum wages and bonus. But for the purpose of payment of wages and equal remuneration, I think these are to be considered to be wages, part of wages. So that is the reason I've just put it in red font. That is number one. Number two, class C. I have highlighted that any contribution paid by the employer to any pension or provident funds in respect of an employee, right? So that is also very specifically getting excluded. Let me explain why it is after going through the next slide, because in the next slide, the definition still continues. Yeah, so here the proviso is there and the explanation is also there. And again, I would like to draw your attention to the underlying portion here. If payments made by the employer to the employee under clauses A to I repeat, clauses A to I, if it exceeds one half, or such other person, currently I think it is only one half, which means 50%. So one half of all the remuneration calculated under this class. So again, when we say all the remuneration, then it is the substantive part, the inclusion part, the exclusion part. All these three parts are to be counted. So the total will give the remuneration. And from that, I think classes very specifically mentioned in the exclusion part from A to I, that is to be deducted. So then the balance will be considered as wages. Again, so there are two key terms. One is remuneration, another one is wage. So when we say remuneration, it includes all payments. So remuneration minus something, it will give wages. That is how mathematically we can put it like that. But when we say classes A to I, now I go back to the previous slide. Class C here, any contribution. So when we say class A to I, definitely that includes class C also, which is any contribution paid by the employer to any pension or provident. Normally, this will not be considered as wages or salary for the purposes of labor laws, at least. But since the proviso very clearly says if the total quantum of classes from A to I, if it goes beyond 50%, if it exceeds one half, then the excess amount will automatically be treated as wages. So there will be some portion connected to the contribution paid by the employer in respect of an employee towards pension fund or towards PF that could get included, right? I think normally this will not be treated as salary, but I am not very sure, since they have mentioned it is A to I, definitely people tend to include this clause also. So it can end up, since this will have some portion of contribution made towards pension or provident fund, maybe employer may end up with paying some PF contributions on again some quantum of PF contribution. So let us see how it can pan out. So as I said in the beginning, maybe the total remuneration is one important term, then wages is one important term. When we say remuneration, it is substantive part, inclusion part, and the exclusion part all put together. That will give the total remuneration, and total remuneration minus the exclusion part, that is from classes A to I alone, right? J and K very clearly excluded, so we need not include that. So that will give the wages. Now I think this is the example. I just thought I could use this for explaining the situation. See, it is a very simple salary structure. Basic DNS allowance, house rent allowance, conveyance allowance, and commission. Again, just for example, basic is 5,000, and the rest of the components, I think 2,500 each. So the total comes to 15,000. So in this, actually, HRA, conveyance allowance, and commission very clearly excluded from the definition of the term wages, right? So what is remaining is basic and DA alone. So when we say, even today, that is the thing. When we say PF contribution, I think we will definitely reckon it only for basic and DA, which means on 7,500. So that will 12% on basic and DA in this example, that will give 900. Now the question is, adding this 900, it is 15,900, right? So now the question is, when we say remuneration, the total remuneration, should I consider this 15,000 or remuneration, or should I consider 15,900 as remuneration? That is a big question. What would be appropriate, in my opinion, is it should be 15,000, right? But since in the definition it says class A to I, which includes PF contributions also, I think people tend to include 900 also, which may not be right, but still there is, I think this could lead to some anomaly unless and otherwise some clarification is given by the government by way of notification or by the department concerned before it is getting implemented. It could be slightly difficult for the employers to go ahead with the compliance in the correct fashion. Maybe now, maybe on your right side, what is the total remuneration, whether it is gross 1 or gross 2? So that is the question. Let us assume that gross 1 is the total remuneration, which means 15,000. 15,000 is gross 1, which is the total remuneration. Now 50% of gross, it comes to 7,500, right? Again, in this example, the sum of excluded components alone, that is HRA, conveyance, and commission, it comes to 7,500. So exactly 50%. So it is not exceeding one half, right? Assuming that 15,000 is the total remuneration. So this, I would say, as per the new definition, this salary structuring is proper. Absolutely no issue in it, right? So, but on the other hand, if we assume gross 2 to be the remuneration, total remuneration, then I think the total quantum will come to 15,900, and I'm sorry, and 50% of it will work out to 7,950, right? But the basic and DA alone, it comes to 7,500, which is less than the 50%, that is 7,950. And the sum of excluded components alone, it is coming to, because it is 15,900 minus 7,500. It is coming to 8,400, right? So when we say 8,400, it exceeds 50%, that it exceeds 7,950. So by 450 rupees. So automatically, as per the new definition, 450 will be added to wages along with 7,500. That is what the new definition, the impact of the new definition would be like that, right? But again, I am not very sure whether we should consider 15,000 as remuneration or 15,900 as remuneration in this example. So this, I think this is this point needs some clarification, right? That is one. The second, the important point is for any purpose, be it minimum wages or payment of wages or bonus or even equal remuneration, the wages part, the quantum cannot go below 50%. Now we know, even if a person is drawing a salary of 1 lakh as gross monthly salary, right? I think the basic and DA portion will work out to just 10,000 or 15,000, and the rest 85,000 or 90,000. I think people mention some nomenclature. They will give some they will say some allowance, this allowance, that allowance, 9 allowances, each allowance 9,000 rupees or 10,000 rupees. So that will come to 90,000, and basic and DA alone will be only 10. So the actual salary works out to 10% of the monthly gross salary. I think the idea of this particular cap being fixed for the exclusion portion is to restrict the employers to not to make the excluded components go beyond 50% of the monthly salary. That should be the idea actually. For any purpose, again, it is not only limited to these 4 legislations under code on wages, even for other codes, right? Occupational safety or social security or the industrial relations code. I think for that also the same definition is there. So for the purpose of labor laws, when we say wages, at least 50% should be there. It cannot go below 50%, right? That is the crux. I move on. So this is when we say COW, it is code on wages. This is how the chapters are currently arranged under the code. We know, see, I think again, I would like to draw your attention to the red font, right? Equal remuneration, minimum wages, payment of wages, and payment of bonus. These are all now 4 separate legislations, but these 4 legislations are now just becoming one chapter under the code, right? So nothing is left out, right? All the administrative areas, the definition portion, everything is made common. That is the idea. The crux of Minimum Wages Act, it's there. It is dealt with in a separate chapter. The crux of Payment of Wages Act, it is dealt in a separate chapter. That's it. I think it is very clearly done, right? So this is how it is arranged, and specific to minimum wages. So what are all I think we are now getting into the third part. So the highlights of the new labor codes. So what is the change, right? So minimum wages will be applicable to all industries and all employees, including managers when fixed, right? Currently, yes, we know the Minimum Wages Act will be applicable to only to those industries which are mentioned in the schedule attached to the Act, right? So it is not automatically applicable to all industries or all companies, no. But that position is getting changed. Once the code is implemented, irrespective of the type of industries, nature of industries, I think Minimum Wages Act will be applicable. That is number 1. Number 2, it will be applicable to all employees, right? The point is, for each employment, for a manager or say for a clerk or for an executive, the minimum rates of wages should have been fixed. If it is not fixed, then that is fine. Only for that class of employees, it is not applicable, right? Otherwise, once it is fixed by the appropriate government, because I think the appropriate government currently it is fixing the minimum rates of wages, and after the implementation of the codes also, the appropriate governments will continue to fix, right? That is the idea. So the scope of applicability of Minimum Wages Act or minimum wages portion part of code on wages, it is getting expanded now, right? So again, a ceiling fixed for excluded components of wages, I think currently it is not there, but once the codes are implemented, I think this will have telling effect, right? This will have major impact actually. So the total sum of wages other than the excluded components shall be equivalent to or more than the minimum wages. I think that is very natural. So for the purpose of Minimum Wages Act, again, what is the total wage? So what are all the wages components which are excluded? So the balance should give the actual wage. And now we have to ensure that this actual wage, the balance, should be equivalent to or more than the minimum rates of wages fixed. Earlier, it was not this. Earlier, HRA was not excluded. It was included. It was there in the inclusion portion. If you go through the definition of the term wages under the Minimum Wages Act, it includes HRA, right? So what happens, I think wherever the more than minimum rates of wages are paid, I think absolutely there shouldn't be any problem. But there are cases where the industries just pay mere minimum rates of wages, particularly with respect to contract workers. They are just limiting the salary to the minimum rate of wages and assume that 5,000 is the minimum rate of wages for a particular employment, right? And they tend to split it into basic and HRA, right? So basic 3,000 rupees, 2,000 HRA. So total comes to 5,000, and it was considered as sufficient compliance for the purposes of Minimum Wages Act, right? But once the code comes, I think this is not agreeable, because HRA is now excluded. So in this particular structure, that is basic 3000 and HRA 2000, right? Total 5000, right? But HRA is excluded. So for the, as per the new definition under the code, the quantum of wages is only 3000, which is less than 5000, right? So it may not be an issue if we have a component called HRA when we pay much higher than the minimum rates of wages. But wherever we pay minimum rates of wages, I think we should be very, very careful because of the implication, expected implication of the new definition under the labor codes and floor wages and minimum wages. Again, there is a concept called national floor level minimum wages, which is there even today, right? But that does not have the statutory force. It is every year, in fact, the central government is notifying the quantum, and the quantum is also common across India, right? But there is no statutory force, so there is no mandate on the industries or the companies to follow that amount, right? So where the companies for which the Minimum Wages Act is not applicable, sometimes they follow this, right? But it is not again a mandate, except in Puducherry. Puducherry, based on the notification issued by the central government, in turn they issue another notification. So they make it as mandatory, the national floor level minimum wages, right? Now that terminology is changed as mere floor wages, and floor wages will be fixed by the central government, right? So central government will continue to fix the floor wages, and this quantum may not be uniform across the country. It could vary from one geography to another geography. I repeat, floor wage, it will be fixed by the central government, and it need not be uniform. It may vary from one state to another state. But when the state governments, when they fix the minimum rates of wages, the appropriate governments, when they fix minimum rates of wages, they have to ensure that rate shall not go below the floor rate fixed by the central government. So I think this will definitely again, this floor wage now is indirectly made as maybe a statutory mandate. I think the employers were also asking for that, right, in a way, because there will be some clarity now. So again, there are going to be two concepts. One is floor wage, another one is minimum wage. Floor wage will be fixed by the central government. Minimum wage will be fixed by, continue to be fixed by the appropriate governments. But the appropriate governments have to ensure that the quantum of minimum wage cannot go below the floor wage notified by the central government. I think these are all the some of the important significant changes under minimum wages. Now I move on. So the change in definition of the term wages, how could it impact the Minimum Wages Act? So the basic is 6,000, DA is 3,000, and HRA is 3,000. Very, very simple again salary structure. So the monthly gross comes to 12,000. Here the assumption is minimum rates of wages is 10,000. That is the assumption, right? So the monthly gross is 12,000, and which is greater than 10,000. So this is considered as sufficient for compliance purpose under Minimum Wages Act. Currently I'm saying, but as per the new definition of the term wages, HRA is excluded. So in this structure, only 9,000 will be considered as quantum of wages, which is less than 10,000. So this is not a proper structuring, right? But for practical purposes, I think they will take into account the total amount. Right. So, but this, whether if you strictly ask me whether this structuring is proper, no, it falls below, it falls short of minimum rates of wages, right? Because as per the judgment given by the Apex Code in air freight case, the quantum of wages, excluding the components which are very specifically excluded, that should be equivalent to or more than the minimum rates of wages fixed. That is the ruling, and that ruling holds good, right? Even today, I think that this came sometime in 97 or 98. I don't remember exactly, right? But it's a judgment by Supreme Court, so that will continue to apply. So in the as per the new definition, then I think HRA is to be excluded. Maybe in the example which you are seeing in your screens. So the quantum of wages will be only 9,000. It is not going to be 12,000. Right, as per the current provision of the definition of the term wage under the Minimum Wages Act, 12,000 will be considered as wages. But now the quantum is getting changed because of the new definition. Right, so we should be very, very careful. This is just an example. I move on. So now, so yes, from minimum wages, now we move on to payment of wages. And you must be aware again, section 1(6), clause 6 of the current Payment of Wages Act. If you go through that, that excludes the persons who are drawing more than 24,000 as monthly salary, right? Only those people who are drawing less than 24,000 as monthly salary are coming under the purview of the Payment of Wages Act. Currently, I'm saying, but that ceiling is getting removed, which means irrespective of the quantum of wages a person is drawing, he will fall under the scope of the Payment of Wages Act. So all the persons will fall under, whether it could be 1 lakh or 2 lakhs, whatever it is, but all of them will be covered under Payment of Wages Act now, or Payment of Wages portion chapter under Code on Wages. And monthly wages, yes, we all know again, if an industrial establishment has less than 1,000 workers, then I think they have to pay the monthly salary within 7 days after the end of the calendar month, which is normally the wage period, right? But in case if they have more than 1,000 workers, then they can go up to 10 days. They can take 10 days, right? But that 10 days timing, that is removed, right? So irrespective of whether the establishment has less than 1,000 or 1,000 or more than 1,000 workers, they have to pay salary within 7 days after the end of the calendar month. And in case if the advance, I think some companies will have practice of giving some loan or advance, salary advance, we call it, right? I think currently, as per the specifically to Tamil Nadu, as per the rules, I think the recovery shall be made within I think 12 installments, 12 months. It cannot go beyond 12 installments. But now the number of installments is removed, so it can be 12 or 15 or 20 or 24, whatever it is. And in any case, the total deduction made from the salary of a person in a month cannot go beyond 50%. So at least 50% of the monthly salary shall be the take-home pay, right? Currently, yes, even today that is the position under Payment of Wages Act, but there is an exception. If there is a deduction partially or fully going towards cooperative societies, then the total deduction can go up to 75%, right? That is removed now, right? So irrespective of whether partially or fully the deduction is going towards cooperative society or not, the monthly take-home pay of a person in the month shall be at least 50%. It cannot go below that. And full and final settlement, again, we all know that it should be made within 2 working days after the actual date of termination of service. Resignation cases, because it is so it was not included, but now through the court, I think even for resignation cases, the full and final settlement is to be made within 2 working days after the actual date of termination of services. Another important aspect in the definition of the term wages, the gratuity is clearly excluded. Now, currently, if you go through the definition of the term wages as defined under the Payment of Wages Act, right? Some gratuity is mentioned in the inclusion part. Some gratuity is mentioned in the exclusion part also. Usually, the gratuity paid as per the provisions of the Payment of Gratuity Act is considered as excluded from the definition of the term wages, right? But surprisingly, what happened? I think the Madras High Court in Madras Fertilizers case, they held that gratuity is part of wages, so they took it to the inclusion part, right? So they said gratuity is part of wages, right? So once it becomes part of wages, then we all know that in case of contractors, if they fail to make payment of wages to the contract workers, then I think the liability falls on goes back to the principal employer, right? Since the gratuity is made as wages, declared as wages by the Madras High Court, even today the legal position is in Tamil Nadu alone. For the industries operating in Tamil Nadu alone, gratuity is considered as part of wages, and if the contractor is not paying the gratuity, then the liability passes on to the principal employer, right? Now, as per the new definition, I think it is very clear. Gratuity is not there in the inclusion portion. It is very clearly excluded. I think we saw that class J, right? Class J is clearly excluded, which talks about gratuity. Class K is the retrenchment compensation. That is also excluded very clearly. So gratuity is no more considered as part of wages. Now, I think this is code on wages vis-a-vis bonus. Again, if there are 20 or more persons employed in an establishment, as per the Act, in an accounting year, then the bonus part will be applicable, right? Even today, again, the threshold limit is 20, right? Some of the states, I think they have reduced it to 10, but generally it is 20 only. But in the code, they have very specifically mentioned that 20 or more persons are employed in an accounting year. So a question arises, suppose once the Act becomes applicable to an establishment, but subsequently on the third year or fourth year, if the number falls below 20 in a particular accounting year, right, for not even for a single day, the company had employed up to 20. It is only less than 20, entire accounting year. For that accounting year, it appears as per the new definition, the bonus part will not be applicable to the establishment, so they need not pay, right? But I'm not very sure something is missed out, or that is the intention. But currently it is not so. Currently also the threshold limit is 20, but it very clearly says subsequently if the number falls below 20, then the Act will continue to apply. I think that is the case for not only for Payment of Bonuses Act, but even for PF or ESI, that is the situation. So first time once it becomes applicable, then subsequently even if the threshold limit falls below, that will continue to apply. That is how it is. But if we carefully read the wordings under the code, it appears that in every accounting year, at least for a single day, there must be 20%, right? But I'm not very sure. We may have to wait and see how it gets developed. And again, a person who is drawing less than 21,000 as salary per month, he will become eligible for payment of bonus, right? And when it comes to the question of calculation, it will be restricted to 7,000 or minimum rates of wages, whichever is higher, which will be applicable to that person. That is how it is. So for eligibility purpose, the salary ceiling is 21,000. For calculation purpose, it is 7,000, right? That is how it is currently, and it is applicable across India as per the Payment of Bonus Act. But this is a dynamic factor. As I said, when we discussed the rationale, right? This dynamic factor, now the powers are given to the appropriate government. So this salary ceiling, both for eligibility as well as for calculation, it can vary from one state to another state. It is possible, right? We may have to wait for the notifications from the appropriate governments. And finally, again, the impact of change in definition of the term wages, 50%. Now, I think we will consider only basic and DA for calculating bonus, right? Other allowances are very clearly excluded, right? But the definition is now common for all the purposes. So it cannot go below 50%. Maybe I have an example here. Again, the basic and DA here, it works out to 10,000 plus 4,000, right? So 14,000. HRA, conveyance allowance and commission, it comes to maybe 5,000 each. So the total monthly salary comes to 29,000, right? So when we say 29,000, the exclusion portion, HRA, conveyance and commission, the quantum comes to 15,000, which is more than 50%. It is, I think, 500 rupees more, right? So first place, this structuring is not proper, right? That is number one. And today, as per the provisions of the Payment of Bonus Act, we will calculate bonus only on 14,000. So we will consider 14,000 as wages for the purpose of bonus. But I think since there is a ceiling for calculation, which is put at 7,000, we will restrict the calculation to 7,000, right? But as per the new definition, wages under code, I think the deemed wages would be 14,500, right? So it will not just stop with 14,000. It will be 14,500. Of course, we may have to wait for ceiling, if any, to be fixed, to be notified by the appropriate one. If there is some ceiling, then we can restrict the calculation to that amount. For calculation, if some ceiling is mentioned, then we can restrict it to that. Otherwise, it is to be calculated on 14,500, not on 14,000, right? It is not possible. I move on. So these are all certain common points under the code on wages. Again, 50% cap is fixed for the excluded component. So the underlying point is at least 50% of the monthly salary will be considered as wages for any purpose, right? So the exclusion portion cannot go beyond 50%. That is the idea. Another interesting point is the contractor's payment shall be ensured by the company before the contractor makes the payment of wages to his employees or workers. Right? Today, the payment to be made by the principal employer to the contractor, and the wages to be paid by the contractor to his contract workers. I think both are completely, it appears to be clearly isolated, right? But actually, as per the idea of the engagement of contractor or the contract workers, the contractor has to pay the salary only out of the consideration he receives from the principal employer. If it is independent, then these people are not to be supposed to be treated as contract workers at all. He becomes independent employer. But today, I think understanding legal position is very right. Right? We have a judgment given by Orissa High Court that they very clearly said, right? So if the contract workers, if the contractor hires people to carry out his obligations arising out of the contract he entered into with some employer, only those people are considered as contract workers. If the contractor has the workers already with them, or he himself is a legal entity, regular employees of the contract, he himself is an employer, right? Then he secures a contract. Then for fulfilling the obligations arising out of that contract, he is utilizing service of his own employees. I think today these people are considered as contract workers, knowingly or unknowingly, but that is not the right legal position. But as per the code, I think the definition of the term contract worker, it is also changed. It very clearly excludes the regular employees of the contractor. They will not be considered as contract workers, right? I think that gives some clarity. So maybe again the idea of making payment of wages to the contract workers by the contractor, it should be from out of the consideration he receives from the principal employer. But today, I think that link is not there, right? But of course, now it is brought as a statutory mandate. So I think since it is very clearly spelled out now, I think employers may have to understand and follow this. And the principal employers are liable for minimum bonus for conduct. Again, I don't understand. Personally, I will not subscribe to this point, because when we say bonus is very clearly excluded from the definition of the term wages. Then why should the principal employer be made as responsible for making payment of bonus to the contract workers if the contractor fails, right? Today, I think very clearly with respect to bonus, even if the contractor fails, the liability will not pass on to the principal employer, because bonus is not considered as wages. As per the definition under the code also for wages, bonus is not part of wages. But this is very specifically given in the draft rules framed under code on wages. I think again, legally, I would say, I think this is not right, but I'm not very sure whether this will be implemented as it is, or they will review it. Then inspector to inspector come facilitator. I think this is a welcome change. I think the primary responsible facilitators, and they have both the employers as well as the workers on the compliance, on their obligations, right? So only then they can resort to taking action, right? So I think this may change the maybe the current type of relationship between maybe all the three important stakeholders: the enforcement authority, the workers, as well as the employers. And compounding of offense, yes, I think we saw that when we discussed the rationale. I think it is there in all the four courts for the first time, right? The employer can avail this facility if there is some contravention, and if it goes to a court of law, then I think the employers can come out by paying 50% of the highest fine prescribed. But it may not be available. The facility may not be available for the subsequent times. Only for the first time it will be available. Now I move on. I think we have come to the end on code on wages. Now it is very specifically with respect to occupational safety, health, and working conditions. Right. This is how again the chapters are arranged. Totally, I think you are seeing 14 chapters, and there are a few schedules attached. And again, chapter 11, which is in red font. I think on the right side, I have given it part 1, part 2, part 3. I think part 1 discusses about contract labor. Right. Today, I think Contract Labor Regulation and Abolition Act is a separate legislation. CLRA Act 1970, it's a separate legislation, right? Similarly, Interstate Migrant Workers Act, it's a separate legislation, right? Then Mines Act, separate legislation. Building and Other Construction Workers Act, it's a separate legislation. Factories Act, now these are all becoming parts, part 1, part 2, 8 parts are there, and it is included in occupational safety, health and working conditions. But more, they will discuss about the conditions of work, starting from the working hours. So that is the idea. I move on. So again, specifically with respect to contract labor. So we all know, again, if there are 20 or more contract workers employed in an establishment, then the current CLRA Act will be applicable to that establishment. That is number one. Then in case of a contractor, if a particular contractor engages 20 or more contract labor, then I think the act will be applicable to him, right? So applicability to the establishment is one, applicability to the contractor is another aspect. There are two things, right? But now that threshold limit of 20 is getting increased to 50. So up to 49, I think this portion, this part will not be applicable. But once it touches 50, it will be applicable. I think this should definitely help the employers, at least those who are in MSME sector. And the contract labor definition, I think we discussed on this. Interstate migrant workers, they are all included. I think even today that is the position, right? The contract labor, it includes interstate migrant workers also, because only those who are coming from other states and engaged through a contractor, they are considered as interstate migrant workers as per the current Interstate Migrant Workers Act. So they are automatically contract workers. And the new definition very clearly excludes the persons who are regularly employed by the principal employer. So by the contractor, sorry. So that is what I said when we explained this related point in the previous slide. So if the contractor if the contract himself is an employer, if he himself is running a company or a business, and he has a set of regular employees, right? Those employees, even if they are utilized for the purposes of some other employers, I think they will not be considered as contract workers once the code is implemented. And the definition for the term core activity, it is now defined, right? Currently it is not defined, except in case of Andhra Pradesh. I think they have slightly made a deviation, and they for maybe using the powers given under the current Contract Labor Act, in that state alone, I think they defined what exactly is the core activity, and almost that same definition is borrowed now. So that definition is given. The idea here is, again, we all know under currently section 10 of the Contract Labor Regulation Abolition Act, it talks about the core activity and the perennial nature of activities, right? So if a particular activity which is core and perennial, right, I think strictly speaking that cannot be given on contract. That is the idea, right? It puts a bar particularly on core activities if it is interested, if those jobs are interested to a contractor. So that is the idea of section 10, prohibition of engagement of contractor or contract labor. That is what that particular section is dealing with, right? But employers have a doubt as to what is a core activity, because the term is not defined except in Andhra Pradesh currently. Now I think that particular terminology is defined, and it also very clearly prohibits engagement of contract worker for a core activity. Otherwise, yes, if it is non-core, yes, they can engage. Then contractors having operation multiple states, right, may obtain common license. That provision, it is coming up under Occupational Safety, Health and Working Conditions Code. Again, personally, I have a doubt. That is the reason I've put a question mark behind this, because when we say contractor, common license, but it very clearly says when the contractor has operations in more than one state, they can go for common license. But when we say contractor, it presupposes existence of an establishment. It presupposes the existence of a principal employer. Contractor is not independent. Even if we go through the definition of the term contractor, it goes like the contractor, comma, in relation to an establishment. That is how it goes, right? So he's not independent. But when you say if a contractor is operating in multiple states, he can have common license. I think if it is related to one single establishment, then that is possible. But if it is for multiple employers, I'm not very sure how it is feasible, right? That is the reason I think I have put it in, question marks there. Then similarly, contract labor chapter, if you go through the part 1, the application of the contract labor part 1 chapter, that is described there. There, they have very clearly mentioned that this chapter will be applicable to manpower supply contractor. I'm not, again, I don't understand why they have mentioned it specifically as manpower supply. There are two types broadly. One is manpower supply contractor or a job contractor, or we can call it as works contract, right? But when we go through section 2 of the code, it defines, I think when it defines the term contractor, and it includes both, I think, manpower supply contractor as well as the job contractor. Similarly, if we go through the provision of section 47 of the wage, I mean the code, occupational safety code, I think that also prescribes license for both the types of contractors, that is job contractor as well as manpower supply contractor, but only in section 45, which discusses about the applicability. It mentions specifically manpower supply. I think something is missed out there, right? It should be an error. I feel that would get corrected. And finally, the direct liability for principal employers for the provisions of various amenities, starting from providing drinking water, washrooms, everything, right? I think currently, if you go through section 16 of the current Contract Labor Regulation Abolition Act, the liability is on contractor. Only if the contractor fails, the liability will pass on to the principal employer, right? But as per the code, straight away the liability for providing these amenities to the contract workers, it is lashed on the principal employer. So no question of contractor providing these amenities anymore once the code is getting once the code is implemented. Now I move on. I think now this is with respect to the code in relation to interstate migrant workers. I think we discussed a bit on this. Interestingly, currently, as per the Interstate Migrant Workers Act, only the contract workers, that is people hired through a contractor for engagement in an establishment which is situated in a different state, those people will be considered as interstate migrant workers. So automatically, when we say interstate migrant workers, they will be automatically contract workers in the first place. Only then they can become interstate migrant workers, right? That position is now getting changed. Even direct employees of the principal employer, if they are hired from another state, that they could also be considered as interstate migrant workers, right? And again, currently the threshold limit for applicability is 5 or more, I mean 10 or more, 5 or more currently interstate migrant workers. That number is getting increased to 10 now, right? So if there are 10 or more interstate migrant workers engaged in an establishment, then this particular part 2 of chapter 11 under code occupational safety code will become applicable, right? Earlier it was 5 only. Now that threshold limit is going up to 10. Then in case of fatal accident or serious bodily injury to any such worker, that is interstate migrant workers, it should be reported to the specified authorities in both the home state as well as the destination state, right? It is not just, it cannot be limited to the destination state. So the authority who is there in the home state, for that person also the report is to be submitted, as well as apart from these two authorities, the information shall be provided to the next of kith and kin of the worker injured, right? Again, these are all developments because of our recent experience with regard to the interstate migrant workers during the pandemic. I think sometime during April and May, I think we heard a lot of news about them. And the appropriate government may provide facility of toll-free helpline to the interstate migrant workers, right? I think appropriate government has to provide that. Similarly, for those interstate migrant workers to pursue their studies, I think the appropriate governments, they may have to come up with some schemes. So these are all certain specific items with respect to the interstate migrant workers, which are Currently, it is not there in the Interstate Migrant Workers Act. So these are all brought through the courts. Then Factories Act, again, Factories Act, when we say, I think it is more than 100 sections are there in the Factories Act alone, but some of the key changes, right? Again, which premises will be considered as a factory? Again, basically, there must be a manufacturing process. Again, manufacturing process as defined under the Factories Act. So clearly, there must be a manufacturing process. If the manufacturing process is carried out with the aid of power, right, then there must be at least 10 workers. On the other hand, if it is not carried out with the aid of power, then there must be at least 20 persons for that premises to be called as a factory. That is the current definition, right? So 10 and 20, right? So that 10 and 20 is now getting increased to 20 and 40. So even if the manufacturing process is carried out with the aid of power, there must be at least 20 persons. Only then that premises will be considered as a factory. If it is carried out without the aid of power, then there must be at least 40 persons. Only then that premises will be considered as a factory. Otherwise not, right? Again, this change should help the employers, particularly those who are in MSMEs. And night shift for women with their consent. Again, interesting point. Currently, women workers, they cannot be engaged during the night time, right? Beyond 7 p.m. and before 6 a.m. Right, they cannot be engaged, but of course, with some special permission of the authority concerned, it can go up to 10 p.m., but not more than that. Right, currently that is the situation as per Section 66(1)(b) of the current Factories Act. Right, but in Tamil Nadu alone, because of the judgment given by Madras High Court in R. Vasanta's case, the court said Section 66(1)(b) prohibiting engagement of women employees during night time is unconstitutional. So clearly they have struck down, but only in Tamil Nadu, because there are contra judgments by other high courts, right? So this is only with respect. So even today in factories, without any special permission, women workers can be engaged during night time. It is possible only in Tamil Nadu, but not in other places. But right, but in the court now, I think engagement of women workers during the night time, it is permitted now. Only thing is we have to get the consent as employees from the women concerned. So they have to give their consent. That is the idea. Similar to that, for working overtime, any worker for that matter, it could be men or women, whoever it is, that the consent of the worker consent is to be applied. Right? Currently, it is not the case, because overtime working is a mandate now, statutory mandate. If a person refuses to work overtime, I think the employers can go for taking disciplinary action against that person. Right? It is considered as a misconduct. But as per the code, I think the consent should be obtained from the workers concerned before asking them to work overtime. Right? But in the 2019 draft of the occupational safety, they very clearly mentioned, very clearly specified that consent should be obtained in writing. Interestingly, when this got released in September, I think in writing those words, it got removed. Right? So consent should be obtained. It could be oral also. That is how we can interpret it. Then independent director can't be an occupier. Again, we all know that one of the directors in the board shall be nominated as occupier in case of a factory, and that should be communicated to the authority having jurisdiction over that factory. Right? The purpose is, again, if no nomination is made as occupier, absolutely it is not considered as contravention, non-compliance. It will not be seen as non-compliance, but in case if contravention is noted subsequently, right, any non-compliance is noted, the inspector concerned will have powers to proceed against any of the directors of his choice. Right? If that is to be avoided, then it is advisable for the factories to nominate one person, one director from the board, and intimate to the authority concerned. Once it is done, then I think he can issue notice. In case if he notices some contravention only to that particular person, director, who is nominated as an occupier. That is the significance of this nomination, right? But in that, currently there is no distinction between whole-time director and independent director. Anybody can be nominated, but through the code, I think once it gets implemented, independent directors cannot be nominated, right? So that is the point here. Then in a factory, if there are 1,000 or more workers, then a safety officer is to be appointed. If there are 500 or more workers, then a welfare officer is to be appointed. If there are 250 or more workers, then that occupier shall provide a canteen for the use of the workers, right? The threshold limit of 250, 500 and 1,000, it is now getting reduced. Canteen 250, it is becoming 100. Welfare officer 500, it is now becoming 250. Safety officer 1,000 workers threshold limit, it is now coming down to 500. So indirectly, this could increase the financial commitment to the employers concerned of the factories. Then eligibility for leave, again you must be knowing, a worker in a factory will become eligible for leave if he has worked for 240 days in a continuous period of 12 months, right? At the rate of 1 day leave for every 20 days of work performed. That is how it is currently. So instead of the 240 days, right, that qualifying period, it is now becoming 180, right? So again, if a worker, if he works for 180 days instead of 240 days in a continuous period of 12 months, then that person will become eligible for leave. It is with respect to factories, right, to be availed in the subsequent period, but of course at the same ratio, 1 day leave for every 20 days of work performed. That is how it is. Again, this is beneficial for the workers, but at the same time, this can increase the financial commitment to the occupiers or the employers. These are all certain common points with respect to occupational safety, health and working conditions code. Appointment order made mandatory. Currently, it is not there, right? Except in case of some of the state-specific Shops and Establishments Act. If I remember, I think it is there in Karnataka under the Karnataka Shops and Commercial Establishments Act, and it is there in Andhra also. It prescribes appointment order. Some format is prescribed, and it also says that if a person is appointed, then the copy of such appointment order shall be filed with the authority concerned also, right? But no other state has a mandate, and definitely it is not there in Factories Act also, right? But under the code now it is made mandate. It is going to be a mandate. So appointment orders are to be necessarily issued. More it is for the benefit of the individual workers concerned. And the terminology appropriate government, we all know, I think we saw that there are 13 legislations getting subsumed into occupational safety code, right? Out of the 13 legislations, 4 legislations separately define the term appropriate government. So 4 different definitions. Now it is becoming 1, right? Similarly, establishment, again each act defines the term establishment. Again, the definition will also vary from one act to another act. Now it is going to be common, right? So then if there are 10 or more workers, then I think that place will be considered as establishment. Then the daily hours, weekly hours and other working hours, as I said, dynamic factors, right? So now it is common, particularly with respect to factories. Across India, for all factories, it is common. Now the appropriate governments, through the courts, the powers are given to the appropriate government. So we may have to wait for the notifications from the appropriate government. So it could vary slightly, right? Again, single registrations of 6. Out of the 13 legislations, now we are doing 6 registrations separately. Under Factories Act, 1 registration. Under Contract Labor Act, 1 registration. Under Interested Migrant Workers Act, 1 registration. Under Building and Other Construction Workers Act, 1 registration. Similarly, and out of the 13, under 6 separate legislations, we have 6 separate registrations. Now it is going to be 1 common registration. I think we discussed, we saw that statistics slide. I think the number of registrations to be done, transactional activity, that is coming down. And the registers, returns, abstracts, notices, again, it is all consolidated. And now I think luckily the electronic form of maintenance of records, it is also now getting accepted. I think it was not so with respect to the Labor Department earlier. Now I think now it is permitted, so automatically they have to necessarily accept. And another development aspect is some panel will be formed with the experts on these subjects, and it will be independent from the government authorities or government servants. and I think they are expected to do some kind of audit, particular to the startup companies and other companies which would be notified by the central government, right? So they will do the audit, particularly with respect to the compliance, and they will submit the report. They will submit their findings to the employer concerned, as well as the authorities who have the jurisdiction over that employer, right? So it is more for development based on that observation, maybe whatever report they are giving. I think the government can bring in changes in the act itself. It is possible. And the role of inspector, as we discussed for the code on wages, here also instead of inspector, they will be called as inspector cum facilitator, and more the facilitation will come first rather than the inspection. Then exclusive facilities for transgender. Now I think we are providing exclusive facilities to women workers. Now I think once these codes are implemented, I think the employers may have to provide the facilities to the other gender, third gender also separately, right? That again can increase the cost to the company. Now I think we have come to the end of social occupational safety and health and working conditions code. Now we move on to the code on social security, right? Again, you are seeing on your screens that chapter 3 to chapter 9, I think it discusses with PF, ESI, gratuity, maternity benefit, everything. Again, these are all specific chapters now. These are all not separate legislations. And of course, chapter 13 is with respect to current Employment Exchanges Act. That is now becoming Employment Information Monitoring. I think employment exchanges, I think the nomenclature is likely to be changed as career centers, right? Now you move on. So specifically with respect to PF, no wage ceiling could be prescribed for Provident Fund employee. I have put question mark there, right? So if you go through the definition for the term employee as per section 226 of the code, new code, I think it bars fixing up ceiling, salary ceiling for PF contributions, right? But they say yes, there could be a ceiling which will be announced once the scheme is framed, right? Because it will not be mentioned in the code. It will be there only in this scheme, right? But scheme is yet to be framed, right? But it says even if the ceiling is fixed, salary ceiling, current 15,000, right? So that would be applicable only to employees pension scheme and employees deposit linked insurance scheme. And it appears that it will not be applicable to Provident Fund. But of course, we may have to wait for the scheme to come. But till such time, the new scheme is framed, the existing scheme will continue to apply. There, I think this 15,000 ceiling is fixed, right? So even if a person is drawing more than 15,000, if the company agrees, yes, they can make contributions on the entire salary, or they can restrict the contributions to 15,000. That is possible, right? Till such time the new scheme is framed under the code for the purposes, specifically for the purpose of PF, I think the current scheme will continue to apply. That is given in the code itself, right? And even if ceiling is fixed, right? But for determining the applicability of this portion, PF part, to an establishment, both those people who are drawing less than the ceiling fixed as well as more than the ceiling fixed, all those people are to be counted, right, to determine the applicability of PF to a particular establishment. So it is not just the coverable employees, even non-coverable employees are also to be counted to determine the applicability to the establishment. When we say again applicability with respect to labor legislations, there will be an applicability to the establishment one, then applicability to the individual employee one, right? So now we are talking about the applicability to the establishment. So for that, I think there is a threshold limit which is going to be 20, right? But that 20, you may have to count both the coverable employees as well as the non-coverable employees, right? Today there is a confusion. Should I take into account only the coverable employees or both coverable and non-coverable employees, right? That confusion is now getting removed, right? Then the term employee, it specifically excludes apprentices engaged under the Apprentices Act. Right? That is fine, right? But what will happen to apprentices engaged under the standing orders, certified standing orders? Or what will happen to the trainees or apprentices engaged as per the policy of the company? Today, for the purpose of PF, all these categories are getting excluded, right? But if we go through the definition of the term employee as given in the code, right, only those apprentices who are engaged under the Apprentices Act 1961. Only those people are excluded from the definition of the term employee, right? But this, I think we may have to infer that automatically the other apprentices would be treated as employees and they may have to be covered under PF. Let us see how it gets developed, or we need some clarification when it gets implemented or when the scheme is announced. And we all know again there is an exemption provided under PF. I think the establishments are given section 17 exemption, we used to call it. For I think the establishment themselves will have some trust formed and they will maintain the PF accounts of the employees concerned, right? But for yes, we can continue to do that under once the code is implemented also. But there must be at least 100 employees minimum, right? So only for those establishments the exemption would be given, not for all the establishments. That is the point here. So this is an example again. So basic DA, it comes to 12,000 plus 4,000, total 16,000, and other three components, HRA, conveyance, and commission, 6,000 each. So total comes to 34,000, right? So currently we will consider only basic and DA, which is 16,000, right? But this is less than 50% of 34,000. When we say 50%, it works out to 17,000. But this 16,000 is less than 17,000, which is 15. Which is 17,000, right? So as per the definition, when we apply the new definition of the term wages to this situation, then I think the deemed wages would be 17,000, right? But of course, if there is a ceiling 15,000, we can restrict it to 15,000, right? Otherwise, let us understand wages for the purpose of PF, but as per the new definition, would be 17,000. It will not be 16,000, right? That is the point I just thought I could throw. I move on. So now I think it is with respect to ESI. Currently, yes, only for the purpose of PF, we have that voluntary coverage, even if the number of employees is less than the threshold limit mentioned. But that provision is not there for ESI. But now I think through the courts for ESI also, if the number of employees is below the prescribed limit, threshold limit, I think for ESI it is going to be 10, right? So even if the establishment has less than 10 employees, but if the majority of the employees are agreeing and management is also agreeing, then they can go for voluntary coverage. But if they once they do that, subsequently, if they want to withdraw from coverage, they can do that also. That right is also given to them. And currently, again, plantations, I think the ESI Act is not applicable, right? But once they have 10 or more employees, I think they can make it applicable on a voluntary basis. It is not going to be a mandate. On voluntary basis, they can do that. And those establishments which are involved in hazardous processes or a kind of life-threatening activities, right? Risk activities, then irrespective of the number of employees, threshold limit will not be applicable for those types of establishments. Central government can make ESI applicable through notification, even if there is single employee, only in respect of those kinds of establishments. And for mines also, I think they are to be covered under ESI if they have 10 or more employees. Currently, it is not applicable. ESI Act is not applicable to mines. And presumption as to the accident, particularly while commutation between residence and the place of employment. Currently, it will not be treated as employment injury unless, and I think we have doctrine of notional extension, right? Only if it fulfills that, then that could be maybe as a special case would be treated as employment injury. Then whatever compensation to be provided, that will be paid by the ESI corporation, right? But the default position is going to be changed. When the accident happens, while the person commutes between place of employment and residence, or from residence to place of employment, that would automatically be treated as employment injury. If it is not, then the otherwise is to be proved. So the point here is the default position is getting changed, and ESIC's rights to extend the facilities. See, again, once a person is ought to be registered under ESI Act, or if a person is registered but the contributions in respect of that person, employee, are not paid by the employer, right? There can be cases, instances like that, right? Now, in such cases, these people will not be entitled for availing the benefits from the ESI dispensary, right? But now ESI corporation can extend the facilities to the employees if they are ought to be registered, or if registered but in the contributions in respect of them are not paid by the employers, right? The ESI corporation can extend the benefits and they can claim the cost from the employer concerned. So it is going to be a new provision, and I think they have mentioned this very clearly, capitalized cost. I don't know how they will work it out. You must be aware. And specifically again, with respect to ESI, because of the change in the definition of wages, I think I have two samples here. So basic day earners allowance and house rent allowance, only three components. So in the sample one, it is 12,000 plus 6,000 plus 6,000. The total comes to 24,000, right? Which means, again, this goes beyond 21,000, which is the current ceiling. And HRA is considered as part of wages today, as per section 222, which defines the terminology wages under the ESI Act. So since it goes beyond 24,000, I mean 21,000, the actually this person need not be covered under ESI. So he does not come under the scope of ESI. But in the same case, sample one, if we apply the new definition, then HRA is excluded, which means wages quantum for the purposes of ESI in this example is only 18,000, which is less than 21,000. So this person is to be covered under ESI. So the new definition clearly changes the position, right? Maybe sample two, again, it would be interesting. 8,000 plus 4,000, 4,000. So total 16,000, less than 21,000. So as per the current provision, section 222, right? So I think this person is to be covered under ESI, and contributions are to be made on entire 16,000, right? But if we apply the new definition, wages, the quantum of wages would be only 12,000. It is not 16,000. So though this person is to be covered under, when we apply the new definition also, the quantum on which the contributions are to be made, it is reduced, right? So it is not on 16,000, which could be the current position when we apply the current law, but that position could change when we apply the new definition for the term wages as per the code, right? So that is the reason I think I just thought I could explain it with two samples. I move on. Now gratuity. So again, 50% of remuneration, again, because of change in the definition of the term wages, that will have impact on gratuity also. Again, for the purpose of gratuity, like bonus, we will consider only basic and DA, right? But if the basic and DA is less than 50%, then I think it is not accepted. The deemed wages will go up, right? That is the idea. Then the definition for the term employee, I think this is common. We saw this for PF, right? The apprentices, except the people who are taken under the Apprentices Act, other apprentices, whether they are to be considered as employees or not, that question remains for the purpose of PF. I think same thing, same principle here also for gratuity also, because the definition is common, right? So then the apprentices, as per the policy of the company, are apprentices taken, recruited as per the certified standing orders of the company, whether they are also to be treated as workers or employees for the purpose of gratuity, I think that remains to be seen. Then I think interestingly, the fixed term employment, that is getting recognized now, right? I think the employers have been asking for allowing them to go for flexible employment, that is now getting permitted. But only thing is, from the day one onwards, even if that person is recruited for merely say 2 years or 3 years, from day one onwards, that person will be treated as on par with permanent employees, and he will be entitled for all benefits which are applicable for the permanent employees, right? So yes, you can recruit a person and you can keep that person only for specific term, but during that term, for the entire period, that person will be treated as permanent workers, right? So in this situation, even if this type of persons, if they are serving for less than 5 years, they will become entitled for gratuity, right? So the qualifying period of 5 years may not be applicable for fixed term employees, that is the idea, or fixed term workers. And with respect to working journalists, I think it is going to be 3 years of continuous service, right? Even today under Working Journalists Act, it is 3 years only, but since it is very specifically mentioned in the code, I think I have brought it, right? So it is not 5 years, but it will be 3 years of continuous service in case of working journalists. Now I move on. Again, an example for gratuity. basic DA, HRA, conveyance allowance, commission. So total comes to 34,000. Basic and DA alone is 16,000, which is less than 50%. So exclusion part is more than 50%. So this structuring is not proper. That is number one. But for the purpose of gratuity, the wages will be deemed to be 17,000. So currently we will be calculating gratuity only on 16,000. But once the codes are implemented, then the employer may have to calculate gratuity on 17,000, not on 16,000. I move on. I think code on cost means it is code on social security with respect to other areas. I think there are 9 legislations. No, so crutch shall be provided if there are 50 or more employees. I think it very clearly says, they don't say 50 women employees, right? So it is 50 or more employee. Even if there is no single woman employee, if there are 50 or more employees, then the employer is bound to provide a crutch, right? That is the idea. And there is a doubt today if that establishment is covered under, registered under ESI. Even those establishments are supposed to provide canteen facility, crèche facility or not. That is a question. But it is clear in the code, even if they are registered under ESI, covered under ESI, still they have to provide crèche, right? Then in case of employment exchanges, currently the act will be applicable if there are 20 or more employees in that establishment, right? That 25 is now getting reduced to 20, right? Currently it is 25 or more, that is getting reduced to 20 or more, right? And I think, as I said in the beginning, the nomenclature may get changed. And 50% of the remuneration shall be considered for working out compensation. There is a compensation under the Employees Compensation Act, right? But of course, whatever the monthly salary, 50% of that amount will be treated as wages when the compensation amount is to be calculated. But there is a ceiling now for workman employees compensation also, which is put at 15,000 currently, right from January 2020, the ceiling is raised to 15,000. Then presumption as to the accident while commutation between residence and place of, similar to ESI. Here also it will be treated as employment injury, and if that person is not covered under ESI, then I think the compensation is to be paid under Employees Compensation Act by the employer, right? Then chapter 7, employees compensation. Currently under Employees Compensation Act, the appropriate government definition is not given, right? But I think now, since it is common, it is one among the other legislations in the code, I think the appropriate government definition is now applicable to employees compensation purpose also. And one interesting point is, and this is a major point actually, so it is not only for the persons, workers in the organized sector. So the government is planning to extend the social security to unorganized workers also, or people in the unorganized sector also, right? We call them as gig workers or home-based workers, platform workers, self-employed workers, or wage workers. I think I've given the section number within brackets. When you find time, please go through that more to understand it. So the idea, broader idea is, I think roughly people say that there are 50 crore workers, and out of the 50 crore, only 10% are there in the organized sector. So remaining 90% for up to 45 crore workers, I think these legislations are not applicable to them, right? But now at least social security, not the other codes, at least social security, they may provide for unorganized workers also. That is the idea. Then this is very specific to, again, the assessment part with under code on social security, both for the purpose of ESI and PF. It cannot go beyond 5 years, right? Assessment. Then the role of inspector, again, it is getting changed from inspector to inspector cum facil, same as other codes. And to provide penalty for different types of violations commensurate with gravity. I think penalty in every case, I think it is going up, and compounding of offense, it is there in this code also. And prior to prosecution, opportunity to be provided to employer for corrective action. I think it is to be done by particularly ESI and PF. It is there. And Aadhaar is now made a mandate, right? Establishment of identity of employees or their family members, I think, for availing benefits. We all know the purpose of Aadhaar is very, very broader. So it is not only restricted to the benefits to be availed by the industrial workers. It goes beyond that, right? Even for availing the facility under LPG, or maybe the other kinds of benefits. I think Aadhaar number is essential. So irrespective of whether that person is in the organized sector or unorganized sector, Aadhaar number is very essential. Aadhaar card shall be produced. Now I think we are moving on to the final code, Industrial Relations Code. Again, this is how the chapters are arranged. Trade union is becoming one chapter, chapter 3, and standing orders is becoming one chapter, chapter 4, right? Other voluntary reference mechanism are there already in the Industrial Disputes Act. They remain as separate chapters here, right? Now, I think the definition of the term industry, we all know, I think it was defined in the famous case, Bangalore Water Supply and Sewerage Board case, till I think it was in 1977. Till that time, in fact, the understanding as to what constitutes an industry, it was not clear. I think it got settled only in this particular judgment by the Apex Court. Again, there must be a systematic activity. That is the first ingredient. That systematic activity shall be carried on between the cooperation of employer and workers. That is the second ingredient. And thirdly, that activity or service is for the purposes of solving the human needs or human wants, right? So if these three ingredients are present, then that particular place will be considered as an industry, right? There could be exceptions that is totally different. I think domestic services and maybe the religious institutions, charitable, social, or philanthropic services, they are all very clearly excluded. Interestingly, again, that is why, in fact, the religious places, temples are excluded, right? Because maybe there also, I think, systematic activity is there, right? And it is also done with the cooperation of employer and workers, right? But the third ingredient, that is to fulfill the human wants or wishes, it is not getting fulfilled, because chanting mantras, it says that it is not to satisfy the human beings, but it is to satisfy the God. So that third ingredient is not satisfied. So that place is not considered as industry. I think that's an interesting argument. I think that was discussed in one particular case. And the concerted mass casual leave, right? I think the industries have been requesting for this for quite a long time. Now it is made as a part of strike, right? If more than 50% of the workers, if they go on casual leave, that will be treated as strike now, right? Illegal strike. Similarly, willful go slow on the part of the workers, right? It could be considered as unfair labor practice, and the employers can take action. And next point is very, very important: the permission for laying off or retrenching or closing down of the place of business. I think currently we call it as Chapter 5B, very prominent. That chapter will be applicable if there are 100 or more workers. That threshold limit is now getting increased to 300. So for up to 300, I think the factory or mine or plantation, only for these types of establishments it will be applicable. If they have up to 300 workers, then I think for retrenchment, for laying off, or for closing down, they need not seek the permission. Only if they have 300 or more, they have to get the permission, right? I think this is a moot point with which I think the strike was announced on for November 26th, but I think that has slightly changed now, because I think that became farmers' strike now. And workers reskilling fund. So in case of retrenchment of workers, I think the management will be paying 15 days of wages for every completed year of service for the retrenched worker, right? Apart from this, mere 15 days wages is to be contributed by the employer to the fund called reskilling fund. The idea is to reskill the retrenched workers so that their services can be utilized elsewhere. That is the idea. Then the maximum number of members of the grievance redressal committee increased from, yes, there is a GRC, grievance redressal committee, prescribed under Industrial Relations Code. I think the maximum number currently under ID Act is 6. That is now getting increased to 10, right? And before going on a strike, I think notice is to be issued, served. I think it should lie from 14 days to 6 weeks, which means roughly 42 days. So once the notice is issued, at least 14 days time they should give minimum. Then after 14 days, before expiry of 42nd day, they can go on strike. That is it. Beyond 42 days, they cannot go, right? But now instead of 14 and 42, now it is beginning 14 and 60 days. That is number one. Number two is this is more applicable to only those establishments which are in public utility services. Now through the courts, it is made applicable to private establishments also, right? Let us see how this is going to pan out. And time period for filing grievance application through the grievance committee, it is reduced from 3 years to 1 year. If there is some grievance, I think they can submit application, they can bring it to the knowledge of the committee. They can take 3 years time, but now that is getting reduced to 1 year. Similarly, for raising industrial dispute, now I think 3 years, up to 3 years they can raise it, but that 3 years timeline is now getting reduced to 2 years. And I think this is the final slide. And this is with respect to industrial relations code vis-a-vis standing orders and trade unions, right? Certification of trade standing orders, again, the Industrial Employment Standing Orders Act. Currently, it is applicable to industrial establishments which engage 100 or more workers, right? That 100 now getting increased to 300. Again, this could support the employers. Then deemed approval provision. If the application for certifying the standing orders, draft standing orders, it is submitted. If there is no response for 60 days, then it will be deemed that approval is given, right? Hitherto it was not there. Now it is getting included in the code. Then fixed term employment, I think we discussed on that. Even for a permanent nature of work, employers now can engage people for a fixed term. It could be decided as per the contract, right? But only thing is, from the day one onwards, that person is to be treated as permanent employee. Then trade union, yes, this could support the trade unions actually. Compulsory recognition is brought in, right? Particularly when the trade union has the support of more than 50% of the workers, right? That trade union is necessarily to be recognized, right? Particularly if there is a sole trade union, then that sole trade union is to be recognized. If there is multiple trade unions, then the one trade union which has the support of more than 50% of workers, that is to be recognized. In case if none of the trade unions has the support of more than 50% of workers, then one representative at the rate of 20% of the workers is to be appointed, and a negotiating council is to be formed, right? So it is to be initiated by the employer, right? So anyways, there is going to be some body. There will be a sole trade union, or there could be a recognized trade union, or there could be a negotiating council. It will be there for negotiating with the management. So I think it will be more beneficial for the trade unions or for the workers. It could be a bit of difficult for the employers to manage it. Again, provision for compounding of offense, like in other codes, it is there for the industrial relations code also. I think we have come to an end. Once again, thank you so much for the opportunity provided. I hope that you would have found this session interesting. And one point, whenever I complete this session, people used to ask for the PPT, right? I am extremely sorry because the rules are not yet announced. So once that is done, I think only then it will become complete, it will be wholesome, but it can also vary some of the provisions, right? So my suggestion would be, it is better if we have the PPT once the rules are announced, right? Thank you once again, and it is back to you, sir. Vinod, sir.
Thank you, sir. Thank you very much for your excellent and informative talk. I could say it should be really an eye-opener for all of us. This being not a core area of practice, as our president remarked, but definitely based on the changes that has been coming up, it becomes imperative for us to know this so that we could advise our client to take appropriate actions. Thank you very much for your valuable time, sir. Let us see some questions if it has come.
Yeah.
One question had come on a private note. There is a principal contractor and a subcontractor. And in the subcontractor category, there are regular employees and contractual employees. You are mentioning about the regular employees will not be treated as contractual employees, and there will be some effect of coverage on those employees. Can you just explain it again, sir, in detail?
See, the point is, as I said, even today, the legal position is the permanent employees or the regular employees of the contractor. They are not supposed to be treated as contract workers. But unfortunately, neither the employers knowingly or unknowingly have this understanding, or the enforcement authority enforces it actually, right? But there is a judgment very clearly, as I said, Basanta Kumar Mohanty case, judgment given by Orissa High Court, right? But so the point is, the permanent employees of the contractor need not be considered as contract workers, particularly once the codes are implemented. That is very clear in the definition itself they have given. That is number one. Number two, the principal contractor and subcontractor. The subcontractor will also be treated as contractors, right? But in practice, what happens, suppose if a principal contractor has two subcontractors, right? The number of employees engaged by both the subcontractors can be shown as the contract workers working directly under the principal contractor, and they can be made as official contractor, so that both the subcontractors will not come into picture at all, right? That is one. Or on the other side, you can also show two subcontractors as two separate contractors, leaving the principal contractor away. That is also possible. Both are there in practice, right? But we may have to check with the authority concern of our area. Then we may have to go ahead, because some authorities suggest this way, some authorities suggest that way. But ideally, subcontractors are also to be treated as contractors.
Okay.
Yeah.
Will there be any relief on the main contractors, or if the subcontractors are not complying with the rules and regulations or depositing the funds?
Yeah, sure. See, whoever is shown as a contractor in the registration certificate of the principal employer, he will have the ultimate responsibility.
No, regarding the subcontractor's employee working as a contractor, from the subcontractor, he is rendering services to main contractor.
Subcontractor is also working.
There is a contract given to a subcontractor, and his workers are working for this main contractor. There is a responsibility cast on the main contractor that ESI, PF, if it is not paid by subcontractor, it will be the responsibility of the main contractor.
Yeah, see, that is what I am saying. If you are showing the principal contractor as a contractor in the registration certificate, then the liability will be on him technically.
Okay.
If the subcontractor is shown as the contractor, then the liability will be on the subcontractor.
Okay. Okay.
Right. Yeah.
Fine. So if it's registered, then there will be no issues on the main contractor.
Yes.
Okay. Okay.
Yes.
Any questions from your side, Vinod sir?
So regarding this Central Act, now it has been, codes have been implemented. So will there be any contradiction between the state and the center? Then how that is going to be in this case?
I don't think there will be any contradiction, right? I think
state has to update accordingly.
No, we need not change at all. No, the Shops and Establishments Act will continue to be there for each state.
Okay.
So this is the provision of the Shops and Establishments Act is not going to be repugnant to any of the provisions of the central legislation.
Okay.
Right? As you say, if it is repugnant, then the central act will prevail actually. In case.
Yeah.
Yeah.
One more thing regarding this trainers, you said that still clarity is not there.
Trainees.
Trainees. But in our chartered accountants CS, normally, how is that going to affect us? Because now, since everyone is coming under this definition of this, what they say, Wages Act. Employer. So how is that going to change, sir?
No. See, now under the definition of the term employee, as per the code, only the trainees registered under the Apprentices Act, they are getting excluded.
Okay.
Right.
Fine.
But there are other forms of trainees also. Yes. Currently, they are also excluded. But I'm not very sure when the scheme is framed under PF, will there be any mention in the scheme so that the other types of trainees are also excluded, or will they be now considered as employees so that they need to be covered under PF and the employers' contributions will also be there, payout?
Yes. That
right. So that clarity, we may require. Right. But one point is the transitional point. It is very specifically mentioned there. So till such time the scheme is framed, the new scheme, the existing scheme will continue to apply. So that maybe with respect to PF, I think we can continue to apply whatever provision we are now applying, right? At least for 1 year, there will not be any difficulty.
Yes, sir.
Yeah.
A very brief and excellent presentation, sir. Thank you once again, sir. Any members having any doubt can ask the questions.
They can raise hands so that I can unmute them.
So once again, sir, Vardhan sir, very excellent presentation on this total labor law codes. You have given a brief overview of what are the changes, what is the impact that is going to come, which act is going to be changed. So this is really a big eye opener for us, since very few chartered accountants are in the practice of labor practice. So I think lot of changes needs to be updated on our side also in the coming days, since most of the people are now covered. So now over to Secretary sir for vote of thanks. Thank you very much, sir.
Yeah, thank you.
Thank you, sir. Thank you, everyone. Now it's time to bid adieu with a pleasant task of giving vote of thanks. I sincerely thank Sri K. Vardhan sir for sparing his valuable time and covering all the critical aspects on code of wages within the time slot provided and also answering our queries. Thank you very much, sir. Thank you for taking time out for us. I thank C.A. Jalakshmi ma'am for the nice introduction of the speaker. And lastly, but not the least, to all the participants who have turned out in large numbers and stayed with us till the end. Once again, I thank the Almighty and also each and every person and the role played by them for the smooth conduct of this program and achieving a great success. Thank you all for joining us. Please stay safe and use all precautions. Thank you and have a good day.
One important information I want to share about Vardhan sir. His company name Aparajita is one of the leaders, pioneers in the labor law compliance. So just for the information of all members, that they are one of the leading labor law compliance company. Thank you, sir.
Yeah, thank you so much once again. Thanks for the opportunity.
Thank
Best
you,
wishes to each
Thank
member.
you.
Thank you. Yeah.
Thank you, sir.
Thank you, sir.
Yeah.